This is TWiT.
So I would just recommend for anybody who wants to sort of catch up and see how we got here, there's a really good Wikipedia page called Net Neutrality in the United States that takes you through the whole weird back and forth history of net neutrality and Title I and Title II, and I'm not going to try and go through that. I'll just refer you to that page. But the latest salvo over the table tennis net in this ongoing struggle is, here I'll tee it up by saying that the FCC under the Trump administration did away with what was called the Open Internet Order, which was a national net neutrality regulation. That went away under Trump. And California responded by saying, okay, well, we're going to basically duplicate the Open Internet Order here in California with a few tweaks. And they did. And of course, that was challenged in court. And what happened just this last week is the Ninth Circuit, which is our Circuit Court of Appeals in this part of the world, decided that that California law could actually stand. The other side had argued that it was preempted by federal law. There are, certain things that the states aren't supposed to touch because it's the province of federal law. And interstate commerce tends to be one of those sort of hallmark things. But the Ninth Circuit decided no, because there was this reclassification of net neutrality from Title II to Title I. So we're going from common carriers to information services, that this actually takes it out of federal preemption and leaves it to the states. So that's what the Ninth Circuit decided. I'm sure at some point another circuit will decide something else for that part of the country, which means this will wind up in front of the Supreme Court.
That's the question for you.
Yes.
Because remember, let's call a spade a spade. Ajit freaking Pai, who managed to get the net neutrality order out, then said, and by the way, you states, you do it. And then California said, oh yeah, stop me. And and Ajit sued. But the Ninth Circuit Court, which is very liberal, said the FCC has given up their authority to preempt this by saying, this is kind of interesting, that internet access is an information service.
Yeah.
That was the whole debate. Now, this is for the Ninth Circuit. It's federal, right?
Yes, that's the Federal Court of Appeals for our part of the world. And I really, different people will say, yes, there are political overtones to net neutrality, but I have a hard time thinking of it as a political issue where,
I
liberal
agree
or
too,
a conservative.
But everything's political nowadays. That's
right, exactly.
Unfortunate.
But small businesses definitely benefit from net neutrality.
So this was ISPs brought this suit, right?
Yes.
Like Verizon, AT&T.
Yes.
Yeah.
And so we're going to
cable
either
ISPs,
see this go to the Supreme Court or the next move on the chessboard or on the table tennis table. I'm mixing my metaphors. There has been a hope that perhaps Congress would act on this and take this off the table tennis table, at least as far as we're going back and forth in the courts, and then it goes to the federal circuit, and then back to the states, and Congress could circumvent all that by just enacting a net neutrality law. So we'll see if
that would be nice. I don't hold
any of that happens.
Hold high hopes for that, but
yes.
At least the Ninth Circuit has upheld it.
Yes.
And maybe that will be enough, although I think the National Cable Television Association will probably pursue this farther. And, of course, in other states will bring up this and so forth and so on.
Right. And then the other sort of coda to that is, of course, if this does wind up in front of the Supreme Court and lots of other tech policy issues are, coming down the pipe to the Supreme Court, I guess it's worth mentioning that Justice Breyer announced his retirement and a replacement for him is being sought. And there's a really nice piece I really love the Washington Post's Cybersecurity 202. If folks are not reading that, it is a great publication. And Joseph Marks and Aaron Schaffer there did a nice summary of what Breyer's retirement and the impact on the court might be, what sort of issues the court can be expected to take on in the next several years. And as they point out, Justice Breyer was never really involved in a lot of tech policy decisions. So it's not exactly leaving a void there, but that it also appears none of the judges being considered to replace him have a lengthy track record in cyber and privacy cases. But as they point out, they're all in their 40s or 50s, which may suggest a closer familiarity with technology and its pitfalls than some of the older justices. So we can just keep our fingers crossed that whoever replaces Breyer has a little bit more sort of real world experience with the kinds of technologies that they're going to be making important decisions about.